this case has a remarkable intersection with the area of family law, an area that I know very well, having been practicing for more than a decade. I like the term practicing because you never really master it. You're always practicing it. So I'd like to cover this trial and give an understanding of what we're seeing take place throughout the proceedings, on the screen, in the courtroom. And the past 2 days, I've been having, well, let me tell you this. Ever since last Friday, we heard the two attorneys, Mr. Shapiro for the defense, Johns Hopkins All Children's, and Mr. Whitney for the plaintiffs. And they both got into a back and forth with the judge about what this case is actually about. And it resulted in a back and forth over whether Munchausen's by proxy and a diagnosis of Munchausen by proxy was a claim for which the plaintiffs were seeking relief, because that seemed to be the foundation of a lot of what the hospital was presenting in the way of evidence. And at that point in time, I was wondering the same thing. What are we arguing about? I was very confused. I'm going to play a bit of Mr. Hunter's opening statement before we get into the coverage today, and I'll explain why I'm pulling it up as soon as we kind of listen to him talking.
They're going to talk to you about whether or not the overarching allegation against All Children's and its physicians, including even Sally Smith, that they were negligent in Maya Kowalski's care, and that their negligence somehow caused injury. We're going to suggest to you that, first of all, there was no ultimate injury caused, given the condition that she was given to us in. But more importantly, there was no deviation from the standard of care. You're going to hear from different doctors in different specialties that the care that was taken in diagnosing and treating Maya Kowalski, you're going to hear about teams of consultants. You're going to hear about meticulous investigations. You can see that Sally Smith formulated a 45-page single-space report of her review of literally thousands of medical records.
I should have caught this at the beginning, and I didn't. I thought the opening statement for Mr. Hunter was very promising. I thought it was very prepared. It was a demonstration of what when you spend a lot of money on attorneys and what they can present in the way of presentations. The presentation was phenomenal, but I should have caught this. He used the term investigation there, and he used Sally Smith's report. We have a lot of Chapter 39 immunity issues in this particular case. Chapter 39 immunity, for those of you guys who are not familiar with it, the Department of Children and Families, DCF for short, employs third-party contractor, well, a partnership rather, the Child Protection Team, CPT. Sally Smith was the medical director of the Child Protection Team. So this team, in liaison with the Department of Children and Families, what they do is they conduct investigations into allegations of medical child abuse and child abuse, abandonment, neglect. And when they find evidence suggesting that, they file a petition with the court to seek the removal of a child from the parent's custody and care. That was kind of what started, well, I don't want to say started, that was a big part of the facts that we discuss in this whole, I'm going to call it the incident, not the case yet. So a lot of the incident revolved around the investigation and whether the conduct of the hospital in cooperation with that investigation is somehow something that the hospital can be held liable for. Well, the judge has previously ruled, it's gone up on appeal and come back down, that the hospital cannot be liable. They cannot be held liable for actions that were taken that are protected under Chapter 39 immunity. If the hospital is taking action in compliance with orders written by the court, with the DCF investigation, once the DCF has jurisdictional authority to conduct that investigation, if the hospital is compliant with those orders and engaging in furtherance of that investigation, they cannot be liable for that. That has rubbed people the wrong way, but I've been very clear on the law on this one, and the judge has too. The hospital is immune. We had a jury instruction that said that if the hospital is engaging in conduct that is in conformity with these orders, they cannot be held responsible for that. So why is Mr. Hunter talking about that? Why was the focus of the opening statement on the investigation and not some of the incidents that were being described by the plaintiffs in their opening? Now, he glosses over them. He does. He covers them. We're going to go over that in a second. But this part, I should have caught it. And the longer this trial has gone on, the more that this has become interesting to me in how the hospital is presenting their case. I want to be clear here. I'm not right now at this stage in the case. There's competing evidence on whether Maya Kowalski was properly diagnosed with complex regional pain syndrome (CRPS), or whether the hospital was correct in diagnosing or in assuming that it was either conversion disorder or factitious disorder, or heck, the hospital had billing codes for Munchausen's by proxy. But the more that the hospital started focusing on this, I was going, are we missing the forest through the trees? I don't know if that's the right analogy. It might be, it might not. Let me do this though. Let's listen to a little bit more of his closing argument, and then I'll kind of wrap up where my head is. And then that's kind of the preview for where we start with today's testimony and today's arguments.
To come up with her diagnosis, you're going to see a lot of effort and care and expertise went in to the effort made to treat this child at Johns Hopkins All Children's Hospital. We believe that the evidence will be unequivocal. That degree of effort, insight, investigation, and monitoring and care.
There's investigation again.
Comported in every respect with what is reasonable and what is recognized as being reasonable and appropriate by other similar physicians. And we don't believe you're going to hear any credible evidence otherwise. You heard the judge give you a definition of medical negligence. I just kind of paraphrased it. But the point I'm making to you is that the evidence will ultimately show that these doctors and these nurses and this hospital staff acted reasonably and prudently to treat a difficult and challenging case they were presented with, and they did it consistently over 3 months. They don't have to be right under the law. All they have to be is reasonable.
That remark, they don't have to be right, they just have to be reasonable. And at the outset, I was going, well, that's an interesting thing to say in your opening statement when the allegations of the plaintiff were as the conduct. But the more that the case has proceeded, I'm willing to concede that there's contested facts that says that the hospital in their suspicion was reasonable in their suspicion. People were critical of me for listening to the plaintiff's evidence and saying the plaintiff had a strong case. I said, wait till I get to the defense side. I'm at the defense side. And there's testimony from various medical providers about what conditions she presented with, the behavior of the parties in the hospital. But for me, this isn't about that. We're focusing on whether the hospital was reasonable in concluding that there was a possibility of Munchausen symptom by proxy, whether they can make that diagnosis or not, or conversion disorder or something. For me, it's not the diagnosis. This isn't the diagnosis. The crux of the case comes down to a few factual incidents that took place that so far I haven't seen good explanation for. Now, there's still a few witnesses to come. Kathy Beatty is taking the stand on Monday, and she is one of the primary characters involved in several of the incidents. And I, of course, did bring her on Monday because I always say, start strong, finish strong. You start with a strong witness, you finish with a strong witness. So Kathy Beatty there's a lot of gap that has to cover here, because as we sit today, I'm still looking at these various incidents and I haven't heard good explanation for some of the conduct that forms some of the very core of the plaintiff's case. I'm still going to keep an open mind. I have throughout this entire trial. But for me, I'm at a place where, and I wonder if the jury's here too. I don't know. Why haven't I heard explanation about these things? Why is it that we're talking about the diagnosis over and over and over again? If I were to give you that point, let's say that I were to hand that point over to the hospital. Jay Hatch, what if I give you that point? What if I say, okay, here's the point. You can, there you go. No CRPS. If I were to concede that point, how do you still explain the other stuff? And that was one of the things that Mr. Shapiro raised when they were having that discussion last Friday. Was Mr. Shapiro makes the claim and makes the statement very emphatically. He says, I don't care if it was Munchausen symptom by proxy or if it was CRPS, the hospital, the standard of care and the standard of treatment is the same for both. And that put it into my head, basically saying the symptoms that Maya was experiencing, if the pain that she was expressing had either a psychological condition or a neurological condition. The hospitals kind of acknowledged that the standard of care for both of those circumstances was the same: cognitive behavioral therapy, psychotherapy, occupational therapy, and pain management, right? So if the standard of care is the same under both, then why am I still looking at these specific incidents and having concerns? That's the point. Mr. Hunter and Mr. Hughes, Mr. Hunter, throughout the trial, we have learned that Mr. Hunter has been on the emails. He was on the emails when this was in front of the dependency court. He was involved as an attorney for the hospital back then. We have this thing that we talk about as attorneys when we practice and when we have cases that we're litigating, right? When we have cases that we're litigating, there is such a thing as an attorney being too close to the case. If you're too close to the case, you can lose sight of the arguments. You can lose sight of ways that your arguments might be flawed. I think this is a flaw in their argument. So I think this is a flaw on their overarching theme for the case and their continued focus in a lot of the debates. And we're going to get to one of the more heated exchanges today between Mr. Hunter and Judge Carroll. Their continued focus on this case is on disproving CRPS and proving an allegation of medical child abuse on the part of Maya Kowalski. That's not what's at issue here. Rather, those aren't the points that I'm seeing as being the core parts of this case, the core parts of the damages being sought. Now, the damages figure, that dollar figure might be substantially lower than the $220 million that they're seeking. And I have questions on damages and causation when you talk about one of the largest claims, which is the wrong intentional infliction of emotional distress when it comes to Maya Kowalski. I think the plaintiffs haven't really closed that loop for me. Get the connection, make the connection there. That's not there. And I don't know that they really can based on the evidence, unfortunately, because Beata's passed. But when the defense seems intently focused on proving that CRPS didn't exist, I have found myself in the past 2 days, witness after witness after witness after witness going, okay, even if I'm with you here, how does this explain those other things? And it's also what's led me to believe that the judge's rulings on the 403 issue, 403 being the information is relevant, however, the prejudicial effect of the irrelevant information exceeds greatly the relevance of that information to the jury and to the determination of the ultimate issue. A lot of the things that we've been discussing, or a lot of the arguments that these attorneys keep having, is on the 403 issue. How much are we allowed to introduce as far as the ketamine use, as far as the past conduct, as far as Mexico, as far as what's being allowed to be infused? I want you guys to please understand this. I am not talking about whether the DCF investigation was valid or not. I am not talking about medical child abuse existing or not. Even if, let's say hypothetically, even if I were to concede that the hospital was acting in some fashion at some of these occasions in compliance with a valid investigation, and even if there was suspected medical child abuse, and even if all of those circumstances existed, how can the hospital continue to explain that some of these actions were in and furthering the care of Maya? And that's where I'm that right there, to me, that's where I'm struggling. And I'm trying to be as neutral and balanced as I can. I'm trying to be as neutral and balanced as I can in making this assessment. I'm conceding all of the hospital's arguments. If I concede every single argument the hospital is making, how am I there? So the hospital still has a few days left. They still have a few days left. And I'm still going to keep an open mind to all of this. I'm still going to try and give you guys the best explanation that I can of the things that I'm seeing happen in court. But I spent quite a while today contemplating this, and yesterday, because this one is tough for me. Let's finish up with the opening argument and get into some of the testimony.
We will suggest to you the evidence will show that first, they probably were right. But even if they weren't, they were more than reasonable. At the end of all this, at the end of all the evidence, I'll have another chance to visit with you, or my colleague, Mr. Shapiro, will. You're going to hear a lot between now and then. And again, I appreciate very much your attentiveness and your diligence, as does my client and the people at All Children's Hospital. I thank you for your attention and look forward to working with you in the next few weeks.
Thank you, Mr. Hunter, for that. So, yeah, I still have some questions because from what we've heard so far is the photographs, the nurse on the photographs. So Kathy Beatty's depot said that the photographs were a direction from risk management, but we haven't seen anything to substantiate that. The nurse said that the photographs were done and she was there to care after Maya and care for Maya. And I'll concede the hospital's argument there were two sets of photos, but why are they not in the medical records? If they're there for the purposes of care and treatment, why are they not in the medical records? Why are they not in the medical file? Why are they in the risk management file? The EEG room. If the EEG room and that 48-hour observation was taking place for advancing the medical treatment and care of Maya Kowalski, why is Dr. Sally Smith, who's investigating, why is she the one that's instructing or suggesting it? You have to bifurcate the issue of investigation and treatment. You have to. And when the hospital makes a claim of this is a muddy line, the judge has come back and says, yeah, it is. And a lot of it is because of the involvement of someone that you had who had staff access to these records and the conduct of that person who had staff access to the records. So, like I said, I have a lot of questions, and I don't know that we've gotten to the point where I've gotten those answered yet. Now, Kathy Beatty's still to take the stand. And I think the jury, who has taken 54 notepads, 54 notepads worth of notes, they clearly are paying attention too. So I wonder how many of them are going to go back and compare notes between the two sets of testimony. It's a thought. So that's kind of where I'm at right now.